Hello and welcome to the Disability Law Question and Answer session. I am Martin Willemse, partner at Samfiru, Tumarkin and Western Canada practice leader. Welcome to our question session. You're welcome to send us questions through any social media platforms, Twitter, Facebook, etc., YouTube as well. We represent clients with denied disability claims, critical illness claims, and life insurance benefit claims throughout Canada other than Quebec. We also offer radio shows and TV shows on Global, as you may have seen before. We welcome all your questions. They may come in live, and I hope as they come in that we'll be able to answer those questions. There will also be other live shows coming your way in the next few days. So when we speak about disability law, something that we see come up much more regularly these days, as I suppose one would expect, is denied cases, long-term disability claims, sometimes also short-term denied disability claims when it relates to long COVID. More and more studies are being done with respect to the effects of long COVID. Obviously, it is fairly new and there's a lot of unknown factors playing into this, and more research is being done. Recently, there was an article, and I think it was last week in Global News, where it was speaking about a study conducted by the Canadian Association of Mental Health, which had found that there was on brain SPECT scans, inflammation in the brain for people living with long COVID or long COVID symptoms at least. And one of the interesting features was that it wasn't the same for everyone, and it wasn't necessarily a situation where the person was hospitalized, that they were extremely sick. They were sick acutely, but not all of them were sick to the extent that they had COVID requiring ventilation or hospitalization. Some did not get that sick, and they still had the long-term effects of COVID, as can be seen on objective findings now, which is very helpful. Often we find that cases like long COVID or chronic fatigue syndrome, which is also called myalgic encephalomyelitis, fibromyalgia, chronic pain, which may not be identified on scans, and mental health disorders. Those are the cases that are generally denied. They're often referred to as subjective conditions or invisible conditions. The reason for that is you cannot necessarily see it on a MRI or a CT scan or an X-ray. It is quite often based on the self-report of the person making the claim. So when you go to the doctor, for example, and you have had some form of a virus or an illness, sometimes like COVID, I suppose, and you have your ongoing symptoms, people start to live with things like brain fog, they're having difficulty with concentration, they're having difficulty with focus, memory, ability to multitask, etc. These are trademark symptoms of long COVID and also ME, in other words, myalgic encephalomyelitis. These are often difficult cases to prove. It's often difficult for people to find doctors with some expertise in assisting with treatment, etc. And as you may know, lots of the long COVID clinics have been closed down. So people are offered telephone interviews, which may not be the same as an in-person assessment, of course. So if those cases are denied, which we often see, it is based on the fact that the doctors or the insurance company would say there's no objective medical evidence, not to mean that it is not there. When you face a denial like that, if the insurer were to say, we are denying your claim because we believe that there is no objective evidence to support the claim, it is crucial in those situations always to be in touch with your doctors on a regular basis. See your doctor regularly. Make sure that you follow your doctor's advice, so that if you are faced with a denial and you present this to the doctor, you may want to show the doctor the denial letter and have the doctor respond in writing as to why the insurance company made a mistake in denying the claim. You may want to pursue an appeal, which often would be, as we've said before, it is an assessment done by the same insurance company who denied your claim. So when the claim is denied, you have an option to pursue two avenues. One would probably be the appeal, and the other one would be litigation. At that juncture, I highly recommend that you reach out to one of our lawyers who will offer you a free consultation by reviewing your documents, the policy, the denial letter, and your personal circumstances, and then discuss with you what your options are with respect to the denial, how to proceed. You may want an appeal as an option, but then you may also want to file a legal claim where your lawyer represents you. Your lawyer takes over all communications with the insurance company, and your lawyer will be able to, hopefully, and quite successfully, resolve the claim through some form of a settlement. So if you have a denial, first thing first, reach out to one of our lawyers who will provide you with that free consultation. You can contact us at disabilityrights.ca, as you can see on the screen. And as I said before, we offer consultations to people throughout Canada other than in Quebec. So I have a question from, is it T-Doll Ryder, I think? I have been on disability for 3 years now, so my return to work status is changed from my occupation to any occupation. Does my employer still have to hold my job for me or give me an equal job? When I'm ready to go back, or are they only required to hold my job for the two-year my occupation phase? If I no longer have a job to go back to, does the employer have to pay a severance? This is a good question. What I would suggest is to post this question tomorrow, because we're going to have I'll just to give you the date. Tomorrow will be, this will be on Thursday, June the 15th at 12 p.m. Pacific Eastern Standard Time, where Alex Lucifero, one of our employment lawyers, will be hosting a live Q&A. And that question, I would suggest you post to him because it is an employment question. Just on that point, T-Doll Ryder is referring to a change of definition in the long-term disability policy. So the insurance company did accept that for the first 2 years, they could not perform the duties of their own occupation. And then the definition changed to that of any occupation. And the question is, will the employer be required to keep the job? Now, there, of course, is something called frustration of contract, which the employment lawyers can speak about, but generally, there is a timeline, I suppose, that employers may decide that they're going to terminate the position due to that frustration of contract principle. And if that were to happen, it should not affect your LTD claim because your claim is already vested. And again, if there were to be a denial because the insurance company says you can now perform the duties of any occupation, remember, it has to be any occupation based on your education, training, and experience that you could perform within your restrictions and limitations, and that would pay you, if there is no percentage defined in the policy, the same amount roughly as your long-term disability benefits, which is normally 65 to 67% of your pre-disability income. Lots of people do face a denial at that time, and unfortunately lots of people just accept it, that the insurance company is correct because ultimately they make the decision. Do not accept that as correct. Reach out and have a consultation with one of us so we can review it with you and tell you whether we think that the insurance company made the right decision. They often don't, especially when it is a decision that is made at the change of definition. I have another question on YouTube from Jill. Are all LTD policies in Canada required to follow Canadian law? Well, you would imagine so, because it is in Canada. The policy is a contract, and the contract sets out the rights and obligations and has provisions. So rights and obligations means the insurance company has some rights. For example, they may have the right to do an assessment of you, but you also have rights. When you submit satisfactory proof of claim to the insurance company, it is expected that the insurance company must then pay to you long-term disability benefits. And if they don't do so, we would take the position that they are breaching their obligations under the policy. There's another email question from Lily. My insurer has asked me to sign a letter to allow them to estimate my CPPD payments, and they can begin deducting them. I haven't been approved yet. Should I sign this? I think that's a question that you should pose to us maybe contact us so we can review it with you. My concern would be that the insurance company is sending you a letter to estimate the amount. Generally, some policies may say that they can estimate it in any event. It would be interesting to see why they would want your permission to do so. Of course, we don't want that to happen. So the expectation, I think, would be that the insurance company, if the claim is approved, because there will be a retroactive payment, will be able to deduct it. But if it's not approved, I don't believe they should be estimating it. Having said that, I really would want to know more about the situation before we can give you a definitive response. So please reach out to us. We can look at what that actual document says that the insurance company wants you to sign, look at the policy and see where you are in the process. On that point, the reason why this question is asked is most long-term disability policies provide that there are certain offsets, in other words, deductions. One of them is CPP disability benefits. And quite a few of these policies may say that if you do not apply, then the insurance company can estimate the amount. But in this case, it sounds like you have applied. So again, I'd rather know more information about where things are at with you. So please reach out to us, Jill. I have an email question from Lily. My insurer has asked me to sign a letter to allow them to estimate my CPP disability payments so they can begin deducting them. I haven't been approved. Sorry, that seems to be the same question. Question on YouTube from Desis. I have severe migraines, pain, and anxiety. My doctors are confirming fibromyalgia. I'm supposed to return to work in September, but my job is very physical and I don't think I can return. What should I do? First things first, make sure that you see your doctor on a regular basis. If your doctor is recommending that you cease working because of what you've described, you have severe migraines, pain, and anxiety, your doctor has given you a diagnosis of fibromyalgia, which, remember what I said earlier, is quite often deemed to be an invisible or a subjective condition. It says you're supposed to return to work in September, but my job is very physical. If you cannot return, have that discussion with the doctor. And if the doctor agrees, then I suppose, and I would recommend that you follow your doctor's treatment advice. When you say you're supposed to return, I'm going to assume that you are receiving benefits at this time. If the insurance company is denying you because your claim is closing and then you have to return to work in September, reach out to us and we can have a review with you. But I highly recommend that you see your doctor on a regular basis and follow your doctor's treatment advice. If your doctor supports that you are still unable to work because of your medical conditions, follow your doctor's advice, because if you do return to work and you have, it sounds like it's a very physical job, you may face an exacerbation or a worsening of your condition, which may then prolong any other absence from work in order for you to recover. So follow your doctor's advice. If the insurance company is denying your claim, reach out to us. Okay. Sam Lupin, are you eligible for coverage if you have developed an illness due to exposure to hazardous materials on the job? That is a very good question. So first things first, when you say it is an illness that was developed due to exposure to hazardous materials on the job, one of the first things that jump out at me is that if this happened on the job, you may want to apply for WorkSafe benefits as well, because you should have coverage, which I believe you will have. The reason why I mentioned that to you is if this is a workplace injury, which it sounds like it is, the policy with the long-term disability insurer will note that, like I was mentioning with CPP disability benefits, there are other offsets, and one of them is WCB, WorkSafe benefits. So if you're eligible for WorkSafe benefits, the insurance company will want you to apply, because the policy provides that they are allowed to deduct whatever other benefits you may be entitled to due to the same disability. And if you don't, similar to we had with this, the insurance company may say to you, well, then we're going to estimate it. Now, the difference between CPP disability and WorkSafe is the WorkSafe benefits generally are much higher. It's a bigger percentage of the benefit of the income, at least. So it may have the effect that your claim with the insurance company may be completely wiped out, but you must still apply. If anybody says to you, do not apply, that is not correct. You must still apply to the long-term disability insurer. And the reason for this is if you do apply to WorkSafe, they pay you for a year and then they may deny your claim and you may still be disabled. Then you apply to your long-term disability insurer. They will say to you that you have missed the notice of claim provisions. Each policy has certain provisions in them with respect to when you have to apply and have to provide notice and proof to the insurance company. And if you don't, chances are they may very likely deny your claim on that basis because you did not apply within the timelines defined in the policy. So even if your claim is being paid by WorkSafe or some other entity, still submit a claim to the insurance company. They may say to you, okay, well, we've received your claim. we'll approve it, but we're not going to pay you anything because the benefit that you're receiving from WorkSafe is wiping out the long-term disability. But that position may change if WorkSafe stops paying you. So make sure that you apply. And if they deny you, meaning the insurance company, and WCB, WorkSafe, is still paying you benefits, there's also a concern there that there's a limitation period that runs. The limitation period is the timeline within which you can pursue a legal claim against the insurance company. This is crucial to understand. So you don't want to miss that timeline. Generally, it is 2 years from the date of denial. In other words, if you submit your claim, and today, what's today's date? June the 13th, the insurance company writes you a letter and says, we've looked at the evidence, we're not approving your claim, it is now denied. From that date, the limitation period, the timeline within which you can pursue a legal claim starts to run. And it runs continuously, even if you are pursuing an appeal. And it becomes more complicated if your benefits are being paid by WorkSafe, because the timeline on the denied LTD claim continues to run while you're receiving benefits from a different entity. So again, if your claim is denied at that juncture, in other words, you're receiving benefits from WorkSafe, but your claim is denied by the long-term disability insurer, you must make sure that you don't miss the 2-year timeline to file a legal claim. Because if that were to happen, if you did miss it, you very likely will be out of time to pursue any claim, and you may not receive any benefits if your WorkSafe benefit claim were to be denied at a later stage. To keep it simple, if your claim is denied at any time, reach out to us, because then we can discuss with you what the timelines are with respect to filing a legal claim and how that process works. Question from Nina on YouTube. I'm going to be cut off my benefits in the next 3 months. The insurer says I'd reached the end of my 2-year period, but I'm still not able to return to work. What should I do? The first thing you do is you contact one of our lawyers. The reason why I say this is the insurance company has already made the decision 3 months in advance that they are going to deny your claim. And what I discussed earlier is the change of definition period. So they're taking the position that you can now go back to work, not necessarily in your own occupation, but in any other occupation. That is something that routinely happens. We would want to look at what are your restrictions and limitations. What is it that you were doing before? What education and training experience do you have, and how much income you were making? Because if the insurance company, for example, were to say to somebody who was making $200,000, you can now go work in a job that pays you $50,000, that's not correct. So each case has to be assessed on its merits. Don't even try to appeal this in this situation. Reach out to us. We will discuss with you what your options are. And if you know, then you can make the decision how to proceed. But it's crucial that you do so now, because the denial has already happened. Question on YouTube from, that's the same one. My sister was this is from Juanita Breaklight. My sister was in a serious car accident and has suffered a brain injury. She won't likely be able to return to work for some time. Would this be covered by LTD or just through car insurance? It depends on which province you are in, but similar as what I said with respect to the WorkSafe BC or the WorkSafe claim, if you receive benefits from other sources, yes, it may impact your LTD claim, but it is crucial that you still apply to the long-term disability insurer. So Juanita, have your sister apply. Will it be covered by LTD? Possibly. It depends on what the car insurance is going to pay and what their position is going to be. Remember, they may provide benefits for a certain period of time. They may provide benefits that reduce over time, and they may deny that claim ultimately. So for anybody else listening to this, because it seems to be the theme of the day, if you are receiving benefits from other sources, or you are eligible to receive benefits from other sources, it is very important that you still apply to your long-term disability carrier, your long-term disability insurer. Even if it's short-term, you do the same thing. Don't assume that because your benefits are being paid by a different entity, that you don't have to apply. You have to apply to protect yourself if in the future there were to be a denial by the other provider, for example, the car insurer or WorkSafe, and you didn't apply, then the insurer is going to say you missed those timelines. And I've been saying it over and over again, but it is the same thing. It does become complicated. and I have seen various people or various inquiries with specifically this thing where people did not apply, and it does then become more complicated. If you did not apply and they did deny your claim based on because you didn't submit it within the timelines, still reach out to us, because there are various principles in law that we could use to still pursue a legal claim. A question on YouTube from Efthymios. Can you appeal a denial if your claim was denied due to an insufficient amount of time worked? Again, can you appeal a denial if your claim was denied due to an insufficient amount of time worked? I suppose what they're going to say, or the position here, is that the insurance company may say or have said that you were working, for example, 15 hours a week, which means that you did not work the minimum amount of hours to allow you for coverage. There's a term in policies which is called actively at work. It's a defined term, and it may provide that you have to work a minimum amount of hours in order to have coverage. It becomes complicated because if you have a medical condition and you start to work less hours, maybe you work less hours for 6 months or a year even, and your condition progresses, and then you go off work, it may be that when you reduced your hours because of your medical condition, you reduced it so much that you no longer qualified for coverage under the policy. I see this as well. I often refer to this as people are literally working themselves out of a claim. Follow your doctor's advice. If it is so that you have to reduce your hours, at that time, already look into, is it necessary to apply for an LTD claim? Because the insurance company may top you up if you cannot work a certain amount of hours, or if you go back on a graduated return to work. But it's crucial that you make sure that you follow your doctor's advice, and you can reach out to one of us as well to just see. So in this situation, I think you should reach out to us, because I would want to see how long you were working reduced hours and what can be done, because quite often there's still an argument to be made. We have a question from FFR Capital. I've been on LTD since March of 2022. I created a website and social media pages for my hobby prior to going off work back in late 2020. I've recently received a call from the insurance company, fraud management department, stating that my file had been flagged, selected for a disability claim, quality audit. They asked me for copies of my tax filings and business records. I don't have business records because it is not a business, it's strictly a hobby. Can they legally ask me for this type of information? This becomes more difficult, specifically because insurance companies find that social media is a gold mine. The reason why they do this and why they're looking at this is they found your website. I understand that you're using it as a hobby, but the question is, are you making any financial income as a result of the hobby? Not just that, they're also going to be looking at, are you I suppose, let me rephrase this. They're also going to be looking at what your restrictions, limitations are. If you say you cannot do something, but you may be very much involved in the hobby, which I understand is not a business, but if you're making income from it, they may look at the ability to participate in the hobby to see whether that would still satisfy your inability to perform the duties of your own occupation. Can they legally ask you for that type of information? I think this is one thing that I would also want you to reach out to us. But the moment that the fraud department is involved, it tells me that they're looking at this claim, your claim, with a different angle, because they're suspecting that there is income being made. So legally, can I ask you for information respecting your income? I suppose it's a difficult question to answer, but I think that there is a possibility that they can, unless there's another way to show to them that you are not making any money from this hobby, right? And it also depends, if you are making money, how much is it that you are making? It really depends on the actual circumstances, how much you're involved in this hobby. I've seen lots of cases where a person was receiving long-term disability benefits, and then the insurance company did exactly the same thing. They found that the person was involved in a hobby. Sometimes the website may create an entirely different impression from what's actually happening. There's a term used for it, puffery, where the website shows that the person is doing all types of things when actually they're not. It's just done in that way to attract business to the website. So it depends on what you're doing. Lots of policies do provide that the moment that you are engaged in wage or profit while receiving LTD benefits, that your benefits will be terminated. So it is a difficult thing to respond in this forum, but it's good to know that this is happening. I would want you to reach out to us so we can discuss with you what your actual rights are and how this is going to impact your LTD benefit plan, because clearly they're not going to leave this alone. They are going to pursue this further. You can contact us at disabilityrights.ca. That concludes our session for today. Thank you for everybody reaching out to us. We'll do another one of these, I think, in about 3 weeks. The next one is our next Q&A with Samfiru Tumarkin is a employment law Q&A, and that will be live at 12 p.m. Eastern Standard Time on June the 15th. So, and that's with my partner, Alex Samfiru. Thank you for reaching out to us, and I wish everybody a good day.